Wike is a trained lawyer, not a politician who studied law briefly and walked away. A barrister, a member of the body of benchers, the highest regulatory authority for legal practice in Nigeria. A man who by professional formation understands what a court order means, what it requires, and what it costs to defy one. On February 10th, 2026, a sitting judge of the FCT High Court issued an interim order. The order was clear. All parties in a land dispute at plot 4583 Maitama maintain the status quo. Do nothing. Touch nothing. Wait for the court. That order was served on the FCT Minister's office. 14 days later, February 24th, officials of Wike's own Development Control Department arrived at that property with over 50 armed policemen and demolished the fence. While everybody has been debating Wike's demolition agenda across Abuja, the roadside structures, the legal buildings, the parks, nobody is asking the one question that actually matters here. When a minister who uses contempt proceedings as a tool against workers who defy court orders is himself accused of defying a court order, who in this country is actually responsible for enforcing that order against him? That is not a philosophical question. It has a specific answer, and by the time we reach the end of this analysis, you will know exactly what that answer is and why it tells you more about how power operates in Nigeria than anything Wike has demolished. Before we go further, if you are new here, this channel exists for one reason: to give Nigerians the political analysis mainstream media is too afraid or too compromised to deliver. Hit subscribe and stay with me. This gets deeper. Let's establish exactly what we are dealing with. The property at the center of this case is plot number A06/4583, also recorded as Park 2023 in the Maitama district of Abuja. It measures approximately 8,572 square meters. That is a significant parcel of prime real estate in one of Nigeria's most expensive residential and commercial districts. The man who holds the allocation is Alhaji Abubakar Ibrahim, chairman of Micah's Grid Ventures Limited. His allocation dates back to 2006, almost 20 years, obtained when Nasir El-Rufai was FCT Minister. The plot was later reduced to a smaller size from its original 1.5 hectares to accommodate a parking facility for the As-Salam Mosque in the area. That redesign was a formal administrative process. His entitlement to the remaining plot was not affected. For nearly 2 decades, that allocation stood unchallenged. Then, in November 2025, something changed. Ibrahim alleges that without his knowledge, without his consent, and without any formal notice to him, the FCT administration under Wike reallocated his property to a company called Italia Company Limited, a foreign corporate entity. No public explanation was given for why a legally held, decades-old allocation was being revoked and handed over to a foreign firm. Ibrahim did what any person in a constitutional democracy would do. He went to court. His legal team, led by Abuja-based lawyer Bala Dakum, filed a motion marked M/1654/2025 on December 5, 2025, seeking an injunction to stop the defendants from taking forcible possession of his land. On February 10th, Justice Hamza Muazu of the FCT High Court, sitting in Maitama, granted the interim order. His directive was explicit. All parties are to maintain the status quo pending the hearing of the motion on notice. The order was served on the FCT Minister and on Italia Company Limited. That is the court order now at the center of this story. 14 days after it was issued, on the morning of February 24th, officials of Wike's own Development Control Department arrived at plot 4583. They demolished the fence, they demolished the security house. Ibrahim says he received a phone call from a security operative telling him to vacate the property before the demolition team arrived. He was not given time to remove his belongings. His trucks were moved without any inventory being taken. Now, here is what every piece of media coverage of this story has missed, or at least buried. The demolition did not happen before Wike knew about the court order. It didn't happen in some administrative gray zone where his team could plausibly claim ignorance. The minister had been duly served with the court processes, including the interim order itself, before February 24th. His own lawyer, Bala Dakum, made this explicit at a press conference. This action took place after he had been duly served with the court processes and the order. Ignorance is not available as a defense here. The timeline forecloses it. What happened on February 24th happened with full knowledge of a subsisting judicial directive. That is the fact that reframes this entire story.
Let's start with a question that the surface reporting on this case has left completely unanswered. Why was a 2-decade-old, legally valid allocation to a private Nigerian businessman revoked in November 2025 and reassigned to an entity called Italia Company Limited? Not a Nigerian developer, not a public institution, a foreign corporate entity whose presence in this transaction has attracted zero official explanation from the FCT administration. Wike's office has not addressed Italia Company's identity, its business in Nigeria, its connection to the FCT Ministry, or the basis on which it was allocated contested land while a legal process was already in motion. In Nigerian land administration, the allocation of a revoked plot to a foreign company without a public process, without a competitive bid, and with armed security enforcement, particularly while the original title holder is actively in court, is not a bureaucratic routine. It is a political decision dressed in administrative clothing. And to understand what kind of political decision, you have to place the Maitama case inside the much larger pattern of land control that has defined Wike's tenure at the FCT. In June 2025, investigative reporting by the People's Gazette, drawing on internal documents and FCTA officials speaking under anonymity, alleged that Wike allocated roughly 2,082 hectares of prime Abuja land to a company linked to his son, Joaquin Wike, between October 2024 and May 2025. The properties allegedly spanned Maitama, Asokoro, Guzape, Buari, and Gadua, some of the most valuable real estate in the Nigerian capital. The estimated market value was placed at a minimum of $3.6 billion. Wike denied the allegations. His spokesperson challenged accusers to provide evidence. But here is what his spokesperson could not deny. A company called Joak Farms and Estates Limited, linked to Joachim, did receive land allocations in the FCT. His office confirmed it. They disputed the specific district, insisting it was agricultural land in Buari, but they confirmed the allocation happened. That confirmation matters, because once the question is no longer whether a minister allocated FCT land to his own son's company, but only how much and precisely where, the defense has narrowed in ways that his team has not fully acknowledged publicly. Now, layer on this. Internal documents reviewed by investigators showed Wike personally signed 6 certificates of occupancy for Joachim's company on February 25, 2025, bearing file numbers 159134 through 159140. The minister, who is also the administrator executing the president's authority over all FCT land, was the signatory on allocations to his own son's entity. Civil Service Rules, the Code of Conduct for Public Officers under the 5th Schedule of the 1999 Constitution, and basic conflict of interest standards speak to what that means. One senior aide to the minister, speaking to investigators, reportedly said, "When we told the minister in April that he needed to slow down on frequent allocations to his own children, he said he was just starting, because his goal was to make them the largest landowners in Abuja." That quote, if accurate, describes not a policy error, but a deliberate accumulation strategy. A senior aide inside Aso Rock told the same investigators directly, Nyesom Wike is a serious liability to the Tinubu administration. While we're focused on tackling the economy and insecurity, he's busy seizing lands from Abuja residents and reallocating them to himself. And then came the line that tells you everything about the current political calculation. The president would eventually have to decide what to do with the minister, but predicting whether that is going to be before or after the election is beyond my service charge. That is a State House source speaking in June 2025, telling you that the primary variable determining whether Wike faces accountability is not the law, not the courts, not the constitution, but the 2027 general election. Think about what that means for the Maitama contempt case. Wike delivered something critical to the Tinubu presidency in 2023. His defection from the PDP, his public break with Atiku Abubakar's campaign, and his mobilization of Rivers State were not incidental to the Tinubu victory. They were structural. And in Nigerian political arithmetic, that kind of debt does not expire quietly. It is managed, deferred, and calibrated against election cycles. Let's start with the question that the surface reporting on this case has left completely unanswered. Why was a 2-decade-old, legally valid allocation to a private Nigerian businessman revoked in November 2025 and reassigned to an entity called Italia Company Limited? Not a Nigerian developer, not a public institution, a foreign corporate entity whose presence in this transaction has attracted zero official explanation from the FCT administration. Wike's office has not addressed Italia Company's identity, its business in Nigeria, its connection to the FCT Ministry, or the basis on which it was allocated contested land while a legal process was already in motion. In Nigerian land administration, the allocation of a revoked plot to a foreign company without a public process, without a competitive bid, and with armed security enforcement, particularly while the original title holder is actively in court, is not a bureaucratic routine. It is a political decision dressed in administrative clothing. And to understand what kind of political decision, you have to place the Maitama case inside the much larger pattern of land control that has defined Wike's tenure at the FCT. In June 2025, investigative reporting by the People's Gazette, drawing on internal documents and FCTA officials speaking under anonymity, alleged that Wike allocated roughly 2,082 hectares of prime Abuja land to a company linked to his son, Joaquin Wike, between October 2024 and May 2025. The properties allegedly spanned Maitama, Asokoro, Guzape, Buari, and Gadua, some of the most valuable real estate in the Nigerian capital. The estimated market value was placed at a minimum of $3.6 billion. Wike denied the allegations. His spokesperson challenged accusers to provide evidence. But here is what his spokesperson could not deny. A company called Joak Farms and Estates Limited, linked to Joachim, did receive land allocations in the FCT. His office confirmed it. They disputed the specific district, insisting it was agricultural land in Buari, but they confirmed the allocation happened. That confirmation matters, because once the question is no longer whether a minister allocated FCT land to his own son's company, but only how much and precisely where, the defense has narrowed in ways that his team has not fully acknowledged publicly. Now, layer on this. Internal documents reviewed by investigators showed Wike personally signed 6 certificates of occupancy for Joachim's company on February 25, 2025, bearing file numbers 159134 through 159140. The minister, who is also the administrator executing the president's authority over all FCT land, was the signatory on allocations to his own son's entity. Civil Service Rules, the Code of Conduct for Public Officers under the 5th Schedule of the 1999 Constitution, and basic conflict of interest standards speak to what that means. One senior aide to the minister, speaking to investigators, reportedly said, "When we told the minister in April that he needed to slow down on frequent allocations to his own children, he said he was just starting, because his goal was to make them the largest landowners in Abuja." That quote, if accurate, describes not a policy error, but a deliberate accumulation strategy. A senior aide inside Aso Rock told the same investigators directly, Nyesom Wike is a serious liability to the Tinubu administration. While we're focused on tackling the economy and insecurity, he's busy seizing lands from Abuja residents and reallocating them to himself. And then came the line that tells you everything about the current political calculation. The president would eventually have to decide what to do with the minister, but predicting whether that is going to be before or after the election is beyond my service charge. That is a State House source speaking in June 2025, telling you that the primary variable determining whether Wike faces accountability is not the law, not the courts, not the Constitution, but the 2027 general election. Think about what that means for the Maitama contempt case. Wike delivered something critical to the Tinubu presidency in 2023. His defection from the PDP, his public break with Atiku Abubakar's campaign, and his mobilization of Rivers State were not incidental to the Tinubu victory. They were structural. And in Nigerian political arithmetic, that kind of debt does not expire quietly. It is managed, deferred, and calibrated against election cycles.
This is why the most important stakeholder in the Wike contempt case is not Micah's Greed Ventures. It is not Justice Mwazu. It is Bola Tinubu. And specifically, the question of whether Tinubu will allow the judicial process to run its course against his own minister, or whether some form of executive intervention will diffuse the case before it reaches its constitutional stress point. Tinubu has said nothing. His office has released no statement on the contempt proceedings. No spokesperson has addressed the question of whether a federal minister is expected to comply with interim court orders. That silence is itself a political position. And now, here is what almost nobody has connected yet, and it changes the entire picture. The same cadastral zone where the Maitama demolition happened, Zone A06 Maitama District, is the same address of at least one other simultaneous court order against the FCT administration. In December 2025, a separate FCT High Court judge barred Wike, the FCTA, and the Abuja Municipal Area Council from acting on a revocation notice issued over Park number 2008, Cadastral Zone A06 Maitama. A different property, a different claimant, a different judge, but the same district, the same zone, and the same revocation and reallocation pattern. When multiple courts in the same district are issuing restraining orders against the same minister arising from different claimants in the same period, that is not a series of legal coincidences. That is a map of concentrated administrative activity in one geographic area. And when that area happens to be one of Nigeria's most expensive real estate corridors, the political strategy question writes itself. Let's move to what this case means beyond Nyesom Wike, because this story has implications that extend far beyond one minister and one demolished fence. The most immediate concern is what the Maitama case says to every person or business holding a certificate of occupancy in Abuja. Alhaji Ibrahim had a valid allocation. He had held it for almost 20 years. He had documentation. He had followed every administrative process. And in November 2025, without notice, without a hearing, and without any published justification, his allocation was revoked and his land was handed over to a foreign company with armed security backing the transfer. When he sought judicial protection, the court gave it, and the minister demolished anyway. If that sequence of events, revocation, reallocation, armed enforcement, court order, demolition in defiance of court order, does not trigger accountability, then every land title in Abuja is conditionally secure at best. The condition being that no minister finds your property strategically useful for reassignment. That is not a legal technicality. That is the foundation of property rights, or the absence of it. The economic dimension of this is already visible. Investigative data from 2025 showed FDI inflows into Abuja dropping by 12% as erratic land enforcement and unpredictable revocations spooked capital. Property values in premium zones were reportedly eroding annually as the perception grew that ministerial power over land allocation was arbitrary rather than rule-bound. Foreign investors watching the Wike contempt case are not asking abstract constitutional questions. They are asking whether a legal protection they obtained in an FCT High Court is worth the paper it is written on if the minister being restrained chooses to disregard it. The governance dimension goes even further. The FCT administration under Wike has simultaneously been cited for months of unpaid salaries to teachers, health workers, environmental protection staff, and water bureau employees. The irony of an administration that cannot fund basic municipal services while allegedly accumulating billions in prime real estate through preferential allocations is not lost on Abuja residents.
It concentrates the question of whose interests the FCT Ministry is actually administering. And now, the institutional connection that I flagged earlier, the one this analysis has been building towards. What the Maitama contempt case exposes is not simply a minister who defied a court. It exposes a structural gap in Nigerian constitutional architecture, the gap between a court's power to issue an order and any institution's willingness to enforce that order against executive power. Form 48 has been served. The law is clear. The court has done what the court can do. But the enforcement of a committal warrant against a sitting federal minister rests not with the judiciary, it rests with the executive. The police, who reported to the same FCT administration that carried out the demolition, are a federal executive instrument. The DSS operates under executive oversight. The process that would actually place a sitting minister in a correction center requires the active cooperation of the very branch of government whose minister is the subject of the order. That is the structural gap, and it is not a gap that Nigerian jurisprudence has ever formally closed, because no case has pushed this far with this level of public visibility before.
Now, let's be rigorous about this, because any serious analysis of this case has to engage with the strongest version of the opposing argument, not the weakest. The most credible defense of Wike's position goes like this. The FCT Minister has broad statutory authority under the Land Use Act and the FCT Act to revoke and reallocate land that has been misused, left dormant, or that conflicts with the master plan for the capital city. The Maitama plot had been redesigned years ago. The original 1.5 hectare allocation was modified. The FCTA, under this argument, was exercising legitimate administrative authority to reclaim and optimize a capital asset. The court process on this reading was an attempt to frustrate a lawful government function through tactical litigation. That is a coherent argument. It deserves engagement. But here is where it fails. And where it fails is not on the merits of the underlying revocation. It fails on sequence. Once Justice Muazu issued the interim order on February 10th, the legal question was no longer about whether Wike had revocation powers. He does. Nigerian law gives the FCT Minister significant authority over land. That is not disputed. The question became, does ministerial authority over land extend to acting in defiance of a subsisting judicial order? The answer, under every relevant provision of Nigerian law and under the basic constitutional doctrine of separation of powers, is no. The court's interim order did not permanently restrain Wike. It said, wait, let this be heard, maintain the status quo while due process runs. Proceeding with the demolition after that order was not an exercise of ministerial authority. It was a substitution of ministerial will for judicial process. That distinction is not subtle. It is fundamental. Now, let's correct the three most common misconceptions circulating about this case. The first is that this is essentially a private property dispute that has been inflated into something bigger. It would be a private property dispute if both parties were private citizens. The moment the state's minister uses government officials, government vehicles, and over 50 armed policemen to enforce a contested allocation in defiance of a court order, the dispute has left the realm of civil litigation. It has become a question of executive compliance with the rule of law. Those are categorically different things. The second misconception is that Form 48 is essentially ceremonial, a legal formality that never actually results in imprisonment, especially not for a powerful official. This misreads the statute. Section 72 of the Sheriffs and Civil Process Act is not advisory. It provides that a court may commit a person to prison until they obey an injunction-type order. The procedural pathway, Form 48, then Form 49, then committal motion, then warrant, is defined and functional. What is uncertain is not whether the law allows imprisonment. The law clearly does. What is uncertain is whether any enforcement agency in Nigeria will execute a committal warrant against a sitting federal minister. Those are two entirely different uncertainties.
The third misconception is that this case is a coordinated political attack on Wike by opponents. The claimant is a private businessman whose allocation dates back to 2006. His suit was filed in December 2025. The contempt proceedings flow mechanically from the February demolition. There is no evidence that this specific case is orchestrated. And the pattern of restraining orders from multiple different judges in different courts involving different claimants in the same district, that breadth of independent litigation is not consistent with a coordinated campaign. It is consistent with a broad pattern of land administration activity generating broad-based legal resistance. And here's the piece of evidence that almost everyone on both sides of this argument has missed entirely. Wike's own spokesperson, in attempting to defend the land allocation allegations, confirmed that JOAQ Farms and Estates Limited, the company linked to Wike's son, did receive land allocations in the FCT. He disputed the scale, he disputed the districts, but he confirmed the allocation. In doing so, the defense shifted from no allocation to the minister's son to yes, but it was agricultural land in Buari. That is not a defense. That is a partial admission that redirects rather than resolve the question of whether the minister was using the power of his office to benefit his own family's real estate interests. And once that partial admission is on the record, the Maitama case, the Italian company reallocation, the armed enforcement, the court order defiance, sits inside a much more disturbing context.
Now, if what I just told you just surprises you, drop a comment below. I want to know what you think before we get to the part that changes everything. Let's talk about what happens next. Because the strategic moves available to the key players in this case are narrower than they appear, and the signals that will tell you which direction things are heading are specific. There are three realistic trajectories from here. The first is a legal counter-move by Wike's team. Expect an application challenging the validity of service by newspaper publication, arguing that substituted service on a fitting federal minister was procedurally defective or insufficient under Nigerian law. Alternatively, expect a motion to set aside the interim order itself on the grounds that it was granted without adequate consideration of the FCT's statutory authority. This is the standard legal playbook. Challenge the process, create delay, push the hearing date. The next formal court date is April 26, 2026. Between now and then, Wike's legal team has room to maneuver procedurally. If they can occupy that space, the practical urgency of the contempt proceedings diminishes. The second trajectory is quiet presidential intervention. Tinubu has two levers available that do not require a public confrontation. The first is a back-channel instruction to Wike. Restore the status quo on the Maitama property, allow the matter to settle, and let the court proceedings become moot. That would resolve the contempt exposure without a public capitulation. The second lever is a ministerial reshuffle, removing Wike from the FCT portfolio before the contempt case escalates past Form 49 into a committal motion. A reshuffle severs the chain of accountability by changing who holds the office, and Nigerian political history is filled with precedents where legal exposure was managed through rotation rather than resolution. Whether Tinubu deploys either lever depends on one calculation: whether Wike's political value going into 2027 still outweighs the institutional cost of protecting a minister under contempt proceedings. The third trajectory, and the one that would have the most permanent institutional consequences, is full judicial escalation. Wike ignores Form 48. His team does not comply. The claimant proceeds to Form 49. The court receives the Form 49 application, hears it, and issues a committal warrant. At that point, the Nigerian state faces its most direct constitutional test on this question in the current era. Will any law enforcement agency execute a court-issued committal warrant against a sitting federal minister? The police commissioner in Abuja reports to a hierarchy that includes the federal executive. The STS operates under the same structure. A court bailiff does not have the capacity to physically commit a minister. The enforcement chain runs through institutions that are, in practical terms, subordinate to the executive branch. This is the gap, not a theoretical gap, but a functional, structural one that no Nigerian court has formally forced the state to close because no case has progressed this far with this level of documented visibility. Here is what to watch for in the weeks ahead. Watch whether Wike's office issues any statement on the contempt notices. Silence is itself information. It signals a legal strategy of non-engagement, which typically precedes procedural challenge. Watch whether the April 23rd hearing is adjourned, because multiple adjournments on Form 49 proceedings historically signal that a quiet resolution is being negotiated off the record. Watch whether Tinubu makes any changes to the FCT ministerial portfolio in the next 60 days. And watch whether other property owners in Maitama Zone A06 file a new action, because the litigation map in that district, if it continues to expand, will eventually become too large for any single political calculation to contain. The time frame that matters for this story is not years away. It is anchored to the April 23rd hearing and then to the 2027 election campaign, which will begin to absorb all federal political energy by mid-2026. Any accountability mechanism that does not activate before that gravitational pull takes hold will be quietly archived. The window in which this case can produce a genuine institutional outcome is measured in weeks, not years.
And now the question I raised at the opening of this analysis. Who in this country is responsible for enforcing a court order against a sitting federal minister? The answer is the President of the Federal Republic. All federal law enforcement instruments, the police, the DSS, the agencies that would physically carry out a commitment, operate ultimately under executive authority. A court can issue the warrant. Only the executive can ensure it is executed. In Nigeria's constitutional structure, that responsibility flows upward to the presidency. So the question of whether Wike will face any consequence from this contempt case is at its foundation a question about whether Bola Tinubu, who has said nothing, whose spokesperson has said nothing, whose government agencies participated in the demolition, believes that his minister is subject to the same legal framework he would apply to a striking worker, a developer who built without permission, or any other Nigerian who disobeyed a court order. That is the answer. And what makes it uncomfortable is that the question of whether Nigerian law applies equally across levels of power is not being answered in the abstract. It is being answered right now, in real time, by a silence that has lasted from February 24 until today. Nyesim Wike is a lawyer who used contempt proceedings to threaten striking workers in January 2026. He is a minister who allegedly demolished a Maitama property in defiance of a court order in February 2026. He is now the subject of the same formal legal process he deployed against those workers. That symmetry is not ironic, it is diagnostic. It shows you exactly how power operates when it believes the formal instruments of accountability are directional, available to the powerful when pointed downward, but navigable when pointed upward. The FCT High Court has done what it can do. The law is clear. The documented record is thorough. What the Maitama contempt case is now testing is not whether Nigeria has functioning courts. It clearly does. What it is testing is whether the institutions that surround and support those courts are willing to treat a judicial order as genuinely binding. Not conditionally, not selectively, but fully, regardless of who is named in the order. The FCT is not just Wike's ministerial portfolio. It is Nigeria's capital. The legitimacy of land titles, the confidence of investors, the security of ordinary residents who hold allocations they believed were protected, all of that rests on a very simple question. Does a court order mean the same thing whether it is served on a union leader or a federal minister? That question is now before the Nigerian state, and we are all watching to see what the answer is. Drop your thoughts in the comments. I want to know, if the committer warrant is issued and no agency moves to execute it, what do you believe Nigerians should do next? What does accountability look like in a system where enforcement is discretionary at the top? If this analysis gave you clarity, share it with one person who needs to understand what's really happening in Nigeria. Like, subscribe, and I'll see you in the next one.